rise. The Honorable Judge presenting over K. Henry is now in session.
You may be seated. Judge Assistant, confirm the detail of the case.
Your Honor, this case concerns contract petition. Mr. Carl rented his flat to Mr. Henry for 2 days. The contract did not mention the coronation, but Mr. Henry argues that the event was the sole reason for renting the flat. Renting counsel proceed with the opening statements.
Your Honor, Mr. Craig provided his rented property as agreed. The contract was valid and Mr. Henry must fulfill his payment obligation. The cancellation of an unrelated event does not resolve contractual duties.
Defense course, your response?
Your Honors, my client read this flat exclusively to view King Edward VII coronation. The event was postponed, eliminating the agreement entire purpose. This contract should be discharged under frustration.
Opening statement conclude. The court shall proceed with witness testimony.
The court calls housekeeper to stand.
Describe your role in the rental arrangement.
I showed Mr. Henry the flat before he rented it. I explained that it had an excellent view of the coronation road.
Did you state that the rental was conditional on the coronation happening?
No, I only mentioned that it will be suitable for the event.
Thank you. By leave, call the next witness.
The court calls legal expert to stand.
Explain the legal principle involved.
Your Honor, the doctrine of frustration applies when an unforeseen events make a contract impossible or radically different from its intent. While the coronation was not mentioned in the agreement, Mr. Henry's intent was clearly tied to it. The unexpected cancellation significantly altered the agreement.
Your Honor, this aligns with the Louis Calvert's 1863 refutation of contract was recognized.
Thank you. Let's proceed with the agreement.
Your Honor, the contract had no explicit condition tied to the coronation. Contract must be upheld even if external events change.
Mr. Henry rented my flat and it was available as promised. He must pay as agreed.
But, Your Honors, the purpose of the contract was clearly tied to the event.
Plaintiff's argument has been recorded.
Your Honors, the contract core purpose was watching the coronation. Without the event, the agreement lost its meaning.
I will never have rented the flat otherwise. Without the coronation, it served no value.
Defendant's argument has been recorded.
Your Honor, Mr. Krell provided his flat as agreed. The defendant must honor his payment. Contract are legal obligation, not subjective expectation.
Your Honors, contract frustration applies. The coronation was essential to the agreement and its cancellation rendered it void.
Your Honor, this case will set a precedent in contract frustration law. If an event is central to an agreement and fails to happen, obligations may be discharged.
After reviewing testimony and argument, I find that the contract was frustrated due to the coronation postponed. The coronation was implied condition fundamental to the agreement. Therefore, the defendant is not obligated to pay the remaining balance. Case dismissed.
All rise. Court is adjourned.
Oh, how it yearned my heart when I beheld in London streets that coronation day. With that single line, William Shakespeare effectively captured England's national mood when a new monarch is crowned. Americans, with our orderly and predictable rituals of presidential succession, may not appreciate the national excitement that accompanies a British coronation. And so it was in 1902. Queen Victoria had reigned for 64 years, the longest reign of any English monarch to that time. So when, upon her death, Edward assumed the throne, his coronation was to be a national event, the likes of which hadn't been seen in the lifetime of most of his subjects. Scheduled for June 26th, it had been a year in the planning, a spectacle to remind the world that, truly, the sun never set on the British Empire. Mr. Henry wanted a place to observe the coronation procession. He found a vacant apartment that offered an ideal view. Paul Krell, the apartment's owner, was out of the country and had authorized his solicitor to rent out the apartment as he saw fit. Henry and Krell's solicitor exchanged letters in which Henry agreed to rent the apartment for 2 days on June 26th and 27th during the daytime only for the price of £75. Henry paid a deposit of £25 with the remainder due on June 24th. None of the correspondence specifically mentioned the coronation, but it was understood that Henry was renting the apartment for those 2 days to witness the big event. But on June 24th, the king was stricken with appendicitis. He became the first monarch ever to undergo abdominal surgery with anesthesia, and while it was successful, the coronation and all attendant proceedings were postponed. His plans ruined, Henry refused to pay the remaining £50. Krell sued him for breach of contract. The trial court held that the occurrence of the coronation procession was an implied condition of the contract. When that didn't occur, through no fault of either party, the contract became unenforceable.